before the break about using entities in asset protection planning, and we were talking about the case of Dr. Brown and the two apartment building he owns, one in the corporation, one in the limited liability company. Dr. Brown gets sued personally, and he loses the stock of the corporation. It gets turned over to the creditors, and with it he loses the apartment building that's in the corporation. And now the question is, what happens to the apartment building that he owns through this limited liability company? So same fact pattern, the plaintiff goes to Dr. Brown. We want apartment building number 2. I do not own it. It's not mine. It belongs to the LLC. Well, it's true, but you do own the limited liability company, just like you own the corporation, and we'll just take your membership interest in the LLC, just like we took your corporate stock. Can the plaintiff do that? Well, it should be obvious based on the way the hypothetical was constructed that the answer should be different from the corporation. And the answer is no, they cannot get Dr. Brown's interest in the limited liability company. His interest in the LLC is not attachable by the creditor. Why is that? Well, the answer is actually very simple, because there is simply no such remedy available to a creditor. With respect to an interest in a limited liability company, an interest in a limited partnership, or an interest even in a general partnership, the creditor simply cannot take Dr. Brown's interest in those entities, or any debtor's interest in those entities. There is no such remedy as attaching an interest in a limited partnership or in an LLC. Okay? They just cannot do it. If they cannot take Dr. Brown's membership interest in the LLC, what remedy do they have available to them with respect to this LLC interest? You know, how do we allow creditors to collect against an interest in a limited partnership or in an LLC? It's done through what is known as a charging order. And the charging order is, this is a creditor's remedy. The charging order is basically the judge directing the LLC to not make distributions to Dr. Brown anymore. And the charging order will have the language that basically says, LLC, next time you decide to make a distribution to Dr. Brown, do not actually give him the cash. Take the cash you were going to give to Dr. Brown, send it to his creditors. That's a charging order. And it functions much like a lien. It's a lien on Dr. Brown's membership interest in the LLC. Okay? And works a lot like a wage garnishment. I mean, conceptually, it's a very, very similar remedy. And, you know, with a wage garnishment, it's an order directed against the employer that says, next time you make payroll payments, do not send the money to this employee, send it to his creditors. Same thing with the charging order. Okay? So the LLC is directed not to make a distribution to Dr. Brown, but instead to send Dr. Brown's share of the distributions to his creditors. You may say to yourself, okay, so they cannot take Dr. Brown's interest in the LLC. They cannot actually take the ownership of the membership interest like they took the corporate stock. But so what? If they can take all of the cash coming out of this LLC, what have you done? Doesn't sound like much of an asset protection advantage there. Well, it's not that simple. First of all, focus on the following. The plaintiff does not get the cash until the LLC decides to make a distribution to Dr. Brown. Let's say that Dr. Brown owns this LLC and he controls this LLC. If Dr. Brown knows that if he is going to make a distribution, his money will go to his creditors, will he make that distribution? Well, hopefully not, right? Hopefully not. And the creditor has no way, absolutely no way of forcing Dr. Brown to make that distribution. There is simply no such remedy available to a creditor. Okay? It's all within Dr. Brown's control. If he decides to make a distribution, the creditor intercepts that money. If Dr. Brown decides to hold the assets within the LLC, there's nothing a creditor can do about it. So let's say that we have this apartment building that the LLC owns, and this apartment building is throwing off rental income. What happens to that rental income? Well, the rental income goes into the bank account that belongs to the limited liability company. If Dr. Brown was to take the money out of the LLC's bank account and transfer it to his own bank account, that would be a distribution to Dr. Brown. And if he makes this distribution, this is when the creditor gets to intercept it. So how can Dr. Brown get around that? Well, there are ways of getting assets out of a legal entity without it being a distribution. For example, Dr. Brown can borrow money from this limited liability company. Dr. Brown can pay himself, I don't know, management fee. He can bring in his best friend or a family member, give them a membership interest in the LLC, and make distributions to this new family member. At the end of the day, Dr. Brown will find a way to get the cash out of the LLC if he wants to, okay? If he wants to, without any money going to the creditors. So given that, you will find that in practice, a charging order is not a very frequently used remedy, because most creditors are well aware of the fact that Dr. Brown controls this LLC, and he will simply stop making distributions as soon as they get a charging order. So not really a viable remedy in most cases. There is one exception. Let us say that Dr. Brown invested in some large oil and gas deal. You know, some huge limited partnership out of Texas. He's one of 1,000 investors. Well, there is a charging order delivered to this limited partnership against Dr. Brown. What is the general partner going to do? To be able to protect Dr. Brown, the general partner will have to stop making distributions to all of the partners of this partnership. Does the general partner care about Dr. Brown that much? Chances are they don't even know him, right? So the general partner will continue making distributions to everyone, including to Dr. Brown, and now his share will be intercepted by the creditor with the charging order. So for this charging order protection to work, this charging order protection that we get from LLCs and limited partnerships, our client has to be in control of that entity. Dr. Brown has to be the manager of the LLC. He has to be the general partner of the limited partnership. If he is in control of the entity, when a charging order is delivered, he is the one who makes the decision, no more distributions are coming out. If he can do that, creditors will get nothing out of this LLC. Now, there are a few questions that very commonly come up when we do this discussion. For example, what are the tax consequences of a charging order? Well, I've heard that, now the creditor is going to be taxed on the income of the LLC. Is that true? Generally, the answer is that even once the creditor gets a charging order, Dr. Brown is the one who continues to be taxed on the income of this LLC. I'm not going to get into too much detail here because it depends on how the LLC is taxed. Is it a disregarded entity? Is it a partnership? Is it a corporation? But the basic idea is that a charging order is just a lien. It's just a lien against Dr. Brown's interest in this limited liability company. Dr. Brown still owns this LLC interest. And if he still owns it, he's the one being taxed on his share of the income in this limited liability company. In some states, including, for example, in California, in some states, the creditor is given the ability to foreclose on Dr. Brown's economic interest in the LLC. And the economic interest is a small portion of his membership interest that basically includes his rights to get distributions of property and cash, and his right to get allocations of income and losses, but it excludes his voting and management rights. So in a foreclosure, the creditor will actually acquire the ownership of the economic interest. Now it's no longer a lien that they have in place. Now they own the economic interest. Dr. Brown still holds all the voting powers, but they now own the economic interest. If that is the case, now the creditor will be the one getting taxed on their share of the income from this LLC, because now they own that underlying interest. So even if they are not getting any cash because Dr. Brown is not making any distributions, if the LLC is generating taxable income and the creditor now owns that economic interest, they will be taxed on that interest, and they will obviously have phantom income. Another reason why this ability to foreclose is usually a completely worthless remedy. I've never seen or known a creditor to pursue this ability to foreclose. Doesn't really get them anything and may actually result in fairly disastrous income tax consequences to the creditor. Another question that commonly comes up is, well, I have a single member LLC.